All right, I do have 9 a.m. on my state-issued computer, so we'll go ahead and get started. Good morning, everyone. For the record, today is Thursday, September 21st, 2023. This hearing is being conducted both in person and telephonically using Microsoft Teams and is currently being recorded. Ms. Gilbert, if you have any technical difficulties or for some reason get disconnected and are not able to rejoin the hearing, please contact either me or Kawana Barbie. I give you her direct line. It's 615-747-5386. You can also email us. Sometimes that's sometimes easier as well. I think you already have our emails, so I won't worry too much about that. We're present today before the Tennessee Assessment Appeals Commission, who have been appointed by the State Board of Equalization to review initial decisions and orders of administrative judges and other related matters. My name is Robin Pope. I currently serve as the Executive Secretary with the State Board of Equalization, and I'm designated to sit with the Assessment Appeals Commission as a hearing officer. As a hearing officer, I preside at the hearing, I rule on questions of the admissibility of evidence, I'll advise the commission members as to the law of the case, and otherwise ensure the proceedings are carried out in accordance with law. I do not participate in their deliberations, or I'm not a decision maker on today's appeal. That is our body here to my left, who will make introductions shortly. During deliberations, when the commission makes their determination, because they will make their decision today and on the record during their deliberations, Mr. Matthew Childress across from me will serve as counsel to the commission. He will assist the commission with questions during deliberations and offer guidance regarding the legal sufficiency of their decision. I will now ask our panel members to otherwise introduce themselves for the record. In no particular order, I guess from my right to left, we'll start with Ms. Clanton.
Rhonda Clanton.
Bill Russ. Rhett Turner.
Van Bowles.
The current chair of the commission is present today. That's Mr. Phil Russ. As our chair of the commission, Mr. Russ will serve as our presiding member unless you choose to otherwise pass that off to somebody else. As you're probably familiar with, as presiding member, Mr. Russ will concur in the final written decision and otherwise preside over deliberations today. All of the appeals to be heard today are to be conducted based upon the record available before the administrative law judge during the prior hearing. The Assessment Appeals Commission may affirm the decision of the hearing examiner, that is the judge, or remand it back to the judge for further proceedings. The commission may reverse the decision of the judge if they find that the judge's decisions, inferences, or conclusion was either 1, in violation of constitutional or statutory provisions, meaning did the judge follow and apply the law correctly? 2, made upon unlawful procedure. Did the judge not follow some proper procedure or is somehow made an abusive procedure? 3, was the decision arbitrary and capricious or characterized by abuse of discretion or clearly unwarranted exercise of discretion? So much more explanatory, but essentially, was the decision arbitrary? Or 4, was the decision unsupported by evidence that is both substantial and material in light of the entire record? So what that means is in determining the evidence, the commission, that is our body today, they can take into account whatever in the record fairly detracts from its weight, but they can't substitute their judgment for that of the hearing examiner as to the weight of questions of fact. Essentially, if the judge made a determination on a factual basis, they can't re-question that judge or find a different fact, but they can look at the record and see that there was contravening evidence existing in the record. They just can't replace their judgment for that of the hearing examiner. This means no new additional facts, testimony, documents, or other evidence is to be presented to the commission unless it's related to an irregularity in procedure not shown in the record. You'll notice today we're not going to make your oath. We're not going to have you take testimony or swear to tell the truth because you're not giving any testimony today. Today is about oral argument and arguing about why you believe the decision was correct or incorrect. Copy of the record, including the audio recording from the hearing with the administrative judge, along with any written argument submitted by the parties, was given to the commission electronically before today. I also have with me a physical copy of the entire record to be heard today, and we have a copy of the initial decision and order before all our commission members. We will proceed from one case immediately to the next, taking breaks only as necessary. Usually I would call roll for our cases, but since I know you're already here and I know the other cases, we only have 2 cases today, I'm going to skip that. Let's see what else I got here. These proceedings are generally really informal. Board members are allowed to ask questions at any time. Generally speaking, once we've heard all the arguments, I'll describe the charge to the commission members and they'll hand it over to deliberations. And so once we finish our discussion and we move to deliberation, there's no more communication between the commission and yourselves. It'll be their decision to make. If they do have questions, they can reopen the record, but we'll walk through that if that happens. Prior to each appeal, I will read a copy of the order that's under review for today. And then these proceedings are generally informal, so typically the person who goes first is the appellant, which will you, and then we'll have the county offer whatever they would like to say, and then you'll get a final chance for any final comments. Switch it over. That said, I'll move over to our initial decision and order up for review. So I have that this decision was issued on February 22nd, 2023 by Administrative Law Judge Claudia Padfield. It's a case captioned the matter of Sheila A. Van Riper as the petitioner versus the Cumberland County Assessor of Property. I have APD case number 53.01-224919J. This is SBOE number 139536, parcel 188, parcel 6. It's control map 188, parcel 6, special interest 000. I have this as for tax year 2022 and 2022 only. The initial decision order starts with a statement of the case. The Cumberland County Board of Equalization has valued the subject property as follows for the tax year 2022. And then we'll make sure I read the footnote. The footnote says the local board notice does not provide a breakdown between land and improvement values. The appraised value on the assessor of property record card lists a different total value than the value listed on the local board notice. As this appeal is from the valuation as determined by the local board, the value of the local board notice is presumed to be the correct value that is being appealed to the state board. The land value listed in this order is the land value listed on the property record card as submitted by the assessor, and the improvement value is reached after subtracting the land value from the local board notice total value. So that means the local board essentially had a value of land value of $16,600, an improvement value of $238,000 for a total value of $254,600 for an assessment of $63,650. Taxpayer timely appeal to the State Board of Equalization on July 28th, 2022. The undersigned administrative judge conducted a hearing of this matter on January 3rd, 2023 in Nashville, Tennessee. The taxpayer, Sheila A. Van Riper, was present. Ms. Van Riper waived the right to counsel and chose to represent herself with the assistance of James Blankenship. The Cumberland County Assessor's Office, hereinafter Assessor, was represented by Cumberland County Assessor Sandy Gilbert and Deputy Assessor Stacy Reed. The issue to be determined is whether the taxpayer has proven by a preponderance of the evidence that the valuation of a mobile home located on the subject property should be lower than that adopted by the local board. Based upon the following findings of facts and conclusions of law, it is determined that the taxpayer has met the burden of proof and the local board valuation is reduced as to the subject mobile home. Findings of fact. The subject property consists of a 2.7 acres of land, parcel identification number 188 0060000, which is located at 63 Arnold Lane, Grandview, Tennessee. Tax year 2022 was a reappraisal year for Cumberland County. The subject property is improved by 2 residences. Taxpayer and Mr. Blankenship reside in one home. Taxpayer's mother resides in the other residence, which is a mobile home. Assessor assessed the subject property at a total valuation of $224,800. Taxpayer appealed to the Cumberland County Board of Equalization, hereinafter the local board. The local board affirmed the total valuation of $224,800. Taxpayer timely appealed the local board's affirmation of value to the state board. Taxpayer does not contest the value of either the land or the home where she and Mr. Blankenship reside. Taxpayer only appeals the value assessor placed on the mobile home, hereinafter the contested mobile home, which was affirmed by the local board. The footnote notes that as neither the value of the taxpayer's residence nor the underlying land is in question, this order focuses on the value of the contested mobile home only. Number 8, assessor assessed the contested mobile home at a value of $62,630. Taxpayer contended the contested mobile home should be valued at $0. Taxpayer purchased the contested mobile home from Clayton Homes in 2017. At footnote 3, no contract was submitted for review, so it is unable to be ascertained exactly what services were contracted between the taxpayer and Clayton Homes. The contested mobile home also has a cooling system, a detached garage, and a porch. After purchasing and installing the contested mobile home on taxpayer's land, taxpayer learned that Clayton Homes was not properly licensed. Taxpayer filed complaints with the Tennessee Department of Commerce and Insurance Board for Licensing Contractors. At footnote 4, no complaints were submitted for review, so it is unable to be ascertained exactly when any complaints were filed and against whom the complaints were filed with the Department of Commerce and Insurance. Per January 30th, 2019 legal report, the case was transferred to the Division of Fire Prevention with a recommendation that a $5,000 civil penalty for unlicensed activity be authorized against a respondent, quote, for acting as a prime contractor and facilitating an arrangement to have work that was part of the original contract completed by an unlicensed contract and represented as licensed, end quote. It was further recommended, quote, open complaint against alleged home improvement contractor as second respondent and authorize the assessment of a $5,000 civil penalty by contest order and formal charges for unlicensed activity in violation of TCA section 62-6-103 and misrepresenting as a licensed contractor. Taxpayer testified at the hearing that she filed a civil lawsuit against Clayton Homes. Taxpayer testified that the case was dismissed. Taxpayer does not contend that the contested mobile home is unlivable as her mother lives in the home. The contested mobile home is fully insured with State Farm Insurance Company. Assessor rates mobile homes in 5 different categories: excellent, good, average, fair, and poor. Assessor rated the contested mobile home as average with a value of $62,630. The contested mobile home would have been valued at $32,330 if it had received a fair rating and a value of $27,420 if it had received a poor rating. Taxpayer contends that the work performed on the contested mobile home was substandard and below code. The taxpayer contends that the contested mobile home has failed a structural inspection and an electrical inspection. Taxpayer does not contest the valuation, but asserts that the contested mobile home should not be assessed at all. As such, neither assessor nor taxpayer presented any comparable sales. Assessor contends that the affirmed value of $62,630 for the contested mobile home as valued by the local board should be upheld. The applicable law. While all property shall be assessed as real property as an improvement to the land where located. Tennessee Code Annotated 67-5-502, subsection A1. Well, any movable structure and appurtenance that is attached to real property by virtue of being on a foundation or being underpinned or connected with any one utility service, such as electricity, natural gas, water, or telephone, shall be assessed for tax purposes as real property as an improvement to the land where located. Tennessee Code Annotated section 67-5-802, subsection A1. The basis of valuation, as stated in Tennessee Code Annotated Section 67-5, 601, subsection A, is that, quote, the value of all property shall be ascertained from the evidence of its sound, intrinsic, and immediate value for purposes of sale between a willing seller and a willing buyer without consideration of speculative values. Merely disproving assumptions underlying the current valuation or pointing out, quote, the likelihood that a more accurate value is possible, end quote, without more, neither invalidates the levy or judgment under appeal, nor constitutes a prima facie case for a change. Citing Coal Creek Company, final decision order, Anderson, Campbell, and Morgan counties, tax years 2009 through 2013, issued June 25th, 2015. To the extent that either side is trying to change the current assessment of the subject property, each party has the burden of proof to prove a more credible value in this administrative proceeding. State Board Rule 0600-1-0.11, subsection 1. To meet the burden of proof, the party seeking to change the assessed value must show that a preponderance of the evidence supports that change. A preponderance of the evidence means that, considering all relevant evidence, a party's contention of value is more likely than not. See State Board Rule 0600-1-0.11, subsection 1, in Big Fork Mining Company versus the Tennessee Water Quality Control Board. Citation, the Assessment Appeals Commission has observed the best evidence of the present value of a residential property is generally sales of properties comparable to the subject, comparable in features relevant to value. Perfect comparability is not required, but relevant differences should be explained and accounted for by reasonable adjustments. If evidence of a sale is presented without the required analysis of comparability, it is difficult or impossible for us to use the sale as an indicator of value. Taxpayer argues that while the physical structure exists, the contested mobile home does not legally exist since it was constructed by an unlicensed entity. Taxpayer asserts, quote, to apply a tax to this property without considering those factors will result in the state being knowledgeably afforded a benefit from unlawful gain. Taxpayer further argues, quote, as all property must be taxed according to its true and accurate value, standard valuation is clearly inapplicable in this situation in light of fraud in its process, end quote. Analysis and conclusions of law. Upon further review of the testimony and evidence submitted in this matter, the administrative judge finds that the taxpayer has met the burden of proof to establish a more credible value than that adopted by the local board. However, taxpayers' argument that the contested mobile home has no value must be rejected. Taxpayer has not offered any applicable rule, statute, policy, case law, or other controlling authority to support her position that a home built by an unlicensed contractor is not subject to property tax. Taxpayer's mother has resided in the home and continues to reside in the home. As such, the contested mobile home is clearly being used as a residence. The nature of how the contested mobile home was built may affect the value of the home. Taxpayer has argued that the contested mobile home has failed an electrical inspection and has other defects. While assessor's employees went to inspect the contested mobile home and did not see any issues from the exterior of the home, assessor did not present any evidence to contradict the testimony presented on taxpayer's behalf as to the electrical and structural issues. Based upon the testimony of taxpayer and Mr. Blankenship regarding the condition and defects of the contested home, the rating of fair rather than average is an appropriate rating for the contested mobile home. After having reviewed all the evidence in this case, the administrative judge finds that the valuation of $62,630 by the local board should be reduced to $32,330 for the contested mobile home. The value of the land and the value of the other residents' home on the property remains as affirmed by the local board. Here ordered for tax year 2022, it is ordered that the following value and assessment be adopted. Land value of $16,600, improvement value of $207,670 for a total value of $224,270 for an assessment amount of $56,068. So ordered, the initial decision order entered and effective this date, the 22nd of February, 2023, and concludes on that page 7 with her signature. And then the final page is listing the applicable remedies, including appeal to this body, which is why we are here today. That is the administrative decision in order for this appeal. With that said, move over. All right, and for those appearing for the appellant, please introduce yourselves for the record.
Sheila Van Riper.
James Blankenship.
And I'll ask those appearing for the assessor's office or the FLE respondent. I believe that Ms. Gilbert.
Yes.
Just introduce yourself for the record.
Sandy Gilbert?
And just for the record, I think you already said this, but you're the assessor of property.
Yes, Sandy Gilbert, assessor of property.
So like I said previously, generally we'll start with the appellant and then we'll move over. I'm sorry, I didn't get your name, sir.
Blankenship.
Okay. Well, one more thing, if you could, please just state at the beginning specifically what you're asking the commission to do today. That is either to remand the decision back to the judge, reverse the decision of the judge, or affirm the decision. It just helps kind of focus where we're going today and then proceed into your argument.
Run those choices by me again.
Yeah, so they can reverse and then remand the decision. So they would basically find the decision was incorrect and then find what was incorrect and send it back to the judge to make those corrections. They can remand to, perhaps there was, if your argument is there was a factual element that was not fully explored, they can remand the judge to fully explore that factual element. Or otherwise they can affirm the decision, find the decision was correct, and then that would essentially, that would conclude it. There wouldn't be anything further after that.
How about I present what I have and they can make their own decision?
You can do that. It does help sort of narrow these discussions, and if you say what you were asking from the commission, because they can't necessarily do everything under the sun. They're not the same sort of fact-finding body you had previously, so it just helps them understand what your relief you're looking for.
Well, there are issues in two of the first areas. There's misstatement of facts in this, and there's continuing evidence that needs to be explored. There were several areas the judge went into that I don't feel she should have went into.
Okay.
So to start with, the first thing I'd like to point out is on page 1 of your file, Tennessee State Board of Equalization before the administrative judge, based on the following reasons: sales comparison of similar properties. That's incorrect. Our main complaint here has been the fraud in the process. And I would like to read into the record my rebuttal of the initial appeal.
Is this part? Yeah, I think you included this as your part of your appeal filing. Is that right?
Yes.
Okay. Yeah.
Yes. Okay, this is for the current appeal on the last decision. Comes down to plaintiff Sheila Van Riper to apply such a tax burden to the petitioner after the petitioner has met the burden of proof is nothing less than judicial incongruity, especially considering that the only physical evidence submitted was by the petitioner. The assessor offered no objections to or oral arguments contesting the petitioner's claims of devaluation by and through the fraudulent and unlawful acts and omissions of the County of Cumberland and City of Crossville, Tennessee, in their violation of non-discretionary fiduciary duties, state law, and their own city ordinance. Further, the petitioner asserts that in the initial decision and order that there were many erroneous findings of facts, conclusions of law, as well as factually inaccurate representations made. The petitioner agrees with the court that the state has a right to tax the contested mobile home, but only at its actual and lawful value. The petitioner will show that the value is far below value set in this court's initial decision and order. The petitioner will also show the reason and circumstances that led to this massive devaluation is a direct result of the fraudulent and unlawful practices of the local authority having jurisdiction, i.e. Crossville and Cumberland County building departments. On the judge's finding of fact, page 3, line number 10, line 1, taxpayer purchased contested mobile home, Clayton Mobile Homes, along with their notation that no contract was submitted for review. My response: jurisdiction of this court is limited to the matter at hand. Contract details with Clayton Homes between the taxpayer and Clayton Homes is completely irrelevant past the fact that they were impersonating a licensed professional in violation of state law and city ordinance TCA 3916-302A and B, impersonation of a licensed professional, and Crossville Code of Ordinances 11203A and B, obtaining a license and privilege or permit by fraud. Line 10, or item 10, line 2, contested mobile home has a cooling system and a detached garage and a porch. The garage is attached. She got live oral testimony from both myself and the assessor on that. The ALJ took direct testimony from Mr. Blankenship, the assessor, as to the attached garage involving failing structural details. This glaring, factually inaccurate statement is a prime example of how we've arrived at this junction. Page 3, number 11, notation 4. No complaints were submitted for review, so it is unable to ascertain exactly when any complaints were filed and against whom the complaints were filed with the Department of Commerce and Insurance. Response: once again, the court reaches past its jurisdiction as the details of the complaint are relevant to this taxation issue. This court has already acknowledged the relationship between the petitioner and Clayton Homes, as well as the resulting January 19th, 2009 legal report confirming the unlawful actions impersonation of a licensed professional. Page 12. Yes, the taxpayer did testify that the civil action against Clayton was dismissed. The ALJ fails to include without prejudice for procedural reasons. Again, the court reaches far past its role in the civil case in question, has no bearing on this issue of taxation, another factually inaccurate statement. Page 3, number 13, addresses the issue of livability. The petitioner agrees that livability is a big concern regarding valuation. Our response to this is, since the court has raised this issue, does the court consider failing electrical inspection by the state, needed mold remediation, substandard structural issues, work performed by an unlicensed, unqualified entities endorsed by the local authority having jurisdiction by way of fraudulently and unlawfully issued permit to be livable? The reason for this adoption of codes is to assure the minimum standard of health and safety by law. See the commerce description. Number 13, the court states that the contested mobile home is fully insured by State Farm Insurance Company. Response: another factually inaccurate statement, as the court has also had testimony that the coverage does not include work by unlicensed entities, which means the damage and devaluation caused by the government endorsed fraud isn't covered, creating further devaluation as this follows and applies to any future owner until it is brought up to code. See insurance claim and rejection. Number 4, see electrical inspection. Page 4, number 16. Taxpayer concedes the right of the state to lawfully tax the contested mobile home. As the court points out, the basis of valuation is stated in Tennessee Code 675-601A is that the value of all properties shall be ascertained from the evidence of its sound, intrinsic, and immediate value. Purposes of sale between a willing seller and willing buyer without consideration of speculative values. The evidence submitted to this court has been overwhelming in regards to the unsound nature of the structure. Necessary mold remediation, the failed electrical system, as well as the fraudulent permit issued and construction by an unlicensed entity. The unlivability, uninsurability of unlicensed work, all achieved through a breach of mandatory non-discretionary fiduciary duty on the part of the local authority having jurisdiction. Consequences of this fraud directly affects the intrinsic and immediate value. See realtor rejection. Local authority having jurisdiction in violation of state law, local ordinance, and building codes ignores their mandatory non-discretionary fiduciary duty and issues a fraudulently produced document, the permit, This act allowed an unlicensed, unqualified entity to impersonate a licensed professional in pursuit of a criminal act that has caused financial exploitation of the elderly through the devaluation of her investment by way of government-endorsed criminal activity. Petitioner has not only met but exceeded the state board rule, see real report in TCA 3916-504A1 and 2, destruction and tampering with government records. The ALJ again makes blatant false statement of fact in relaying the petitioner's statement as that while the physical structure exists, it does not legally exist because it was constructed by an unlicensed entity. Patently false. Petitioner's actual testimony is it doesn't legally exist because of the fraud in its creation. C 11203 City Ordinance of Crossville, Tennessee, the issuing local authority having jurisdiction. To apply a tax to this property in any fashion, except as the sum of its parts, without considering the fraudulent process and unlawful procedure that has resulted in provable damages in excess of even the original cost of the contested mobile home and the assessor's original valuation, will most certainly result in the state being knowledgeably afforded a benefit from unlawful gain through the criminal conduct of a such sister agency in a breach of fiduciary non-discretionary duty, through the continuance of government-sanctioned criminal activity. Analysis: the petition has met the burden. The assessor did not present any evidence contradict the testimony presented on the taxpayer's behalf concerning any issues. Presented no comps, just a vague description of the process. Petitioner has supplied this court far in excess of the minimum threshold with clear and convincing documented evidence and a prima facie case for change. Certainly the court can now fully appreciate the full extent of the conditions and can see the assessed value is not fair. Fraud and current conditions versus the expense to repair actually causes a negative valuation as the costs are estimated to be $40,000 to $60,000. It is, in fact, far below poor condition value of $27,420 and create a negative value to the taxpayer. Judge may not create any defense or form of prosecution and is charged with considering only the evidence submitted, nor may a judge raise issues not presented. Several inaccurate statements have been made, as well as the raising of issues not presented or contested and having no bearing on the issues of taxation. We submit this issue, this honorable administrative review, and pray for the relief sought by the petitioner and taxpayer. The true value should be assessed according to the evidence submitted. To be that of the material, just the actual components, and the final page as the exhibits that I mentioned in this. Our problem is the fraud in the process. It's very clear that state law, city ordinance, building codes all support the contention that this has been fraudulent all the way through. And I think the state, as well as our local assessor's office, are unknowing victims of this as well as we were when we started out. I can't see the state allowing itself to benefit from obvious misconduct in office, let's say. Maybe that's not the correct word, but I don't. I had a question for the assessor. May I? Is that allowed?
No, these proceedings are mostly just for oral argument. We're not taking any testimony, so there's no questions. The commission, once you're done, I usually ask if the commission has questions of you. But this is not a time for cross-examination or questions of each other.
Okay. Anybody has any questions?
Yeah, I usually hand it over. Commission, any questions?
I listened to the testimony and like mobile home is being lived in and I didn't hear comps.
Could I get you to speak up?
I didn't hear comps that were brought up.
There were none presented, ma'am.
Okay,
By either side, I couldn't.
okay.
Mr. Bowles, do you have any questions?
Like you got two issues. You got a legal issue and a government issue. We're not a legal board.
I understand that.
All your legal comments should be addressed to proper agency. And if you say this thing has no value, then what's your mother doing and living in it? And if the board says, okay, we agree with you, it has no value, what does that change your condition?
I apologize. Go ahead, sir.
So, I don't see any relief from the board that would actually change the condition of this situation. Apparently, the mother is still going to live in it. Now, get back to the elements of the law, where, that this is not legal. This is not a legal board. Hard to connect the dots on issues.
I'm sorry, I can't hear.
It's hard to connect the dots on these two issues. I don't know that the assessor has any, is not in a position to correct the legal issues as well.
Yes, sir. I understand that.
So, a difficult situation. Compassion is probably warranted to some degree, but unless things change beyond what now exists, the structure would have to have some, regardless of the license or unlicensed, we would have to have some type of utility to it. My basic comments, I guess.
Mr. Turner?
May I address?
Oh, so, excuse me, sir. Yes, you can certainly answer his question. Or-
Legal issue is so intertwined with this. It's, I'll admit, a little bit mind-boggling. But fraud in any case is still fraud. And we have not only supplied all the state codes and everything necessary to point out the fraud in every bit of this situation going forward from where it started at. And as far as the house being livable, if you'd like to come over and tell a 78-year-old woman whose biggest dream was to live near her daughter, to move, I invite you to. I have worked diligently to encapsulate the mold, but it still needs remediation. So many things wrong with that place. So, becoming a bigger issue with every day passes. And all because of unlicensed, unqualified by this fraud. This fraud also affects your insurability and even your mortgage. I mean, this is a huge issue as far as if they're doing it right, great, no problem. But they haven't done it right. They haven't done it right from the start, and they've not tried to make it right. They have had plenty of notice and of the unlawful things going on in their department, and they fought it the whole way. And fact is, proof is right before you in the files. default, that goes along with it. The uninsurability also factors in to the sellability, because that nightmare is going to follow property. Sold, new owners are in the same exact position we are with insurance, possibly mortgage issues. It's uninsurable, the bank can up your mortgage or deny you wholesale. Seriously damages our ability to do anything with the place. A regular nightmare, and doesn't seem like I want to acknowledge the fraud. And I don't blame the state, and I don't blame the assessor's office. Like I say, I think it's two groups of people that didn't know anything about this till we stepped up to the plate. And I think with the evidence that we presented, that it does stand to value the place at the value of some of its parts, because parts are steadily deteriorating by the day. Yes, sir. Go ahead, sir.
Turner.
Excuse me, briefly, I think we have several different mitigating issues, but the issue of my understanding of the scope of work that we're here to address is the assessed value of the property. Comparable sales analysis from a qualified real estate appraiser, something of that nature would have been quite beneficial. I would like to have seen and heard that. Many of these issues are outside what I deem as my scope of work. I'm not denying it. I'm not questioning it. I don't think I'm here to vest my opinion in that, because I don't have one. It appears to me that the administrative law judge has already taken into some great consideration by reducing the assessed value of the property improvement in question by nearly half. So I think there has been some concern given and some opinion warranted that is worthy of consideration and value on the part of the taxpayer. I think to say that a structure that is serving its intended value or its intended use as a domicile or dwelling where a person can reside regardless of the condition, to say that structure has zero value is respectfully unacceptable, unfounded. I think your issues probably have warrant in another body, in another place. Those are my humble thoughts.
I read your brief in addressed to the commission here, and in the exhibits you had inspections from an electrical inspection noting the deficiencies. There was a structural inspection noting the deficiencies, and there was a remediation or biological environmental about the mold. After it was built in 2017, correct? And this is
Yes.
2023. Over the 6 years, have y'all tried to do anything to correct these deficiencies? If you got the inspection and there's an electrical deficiency, that could be dangerous. And I didn't, let me finish, please, sir. All right.
Okay, we'll take a brief recess just for a moment then. About 5 minutes. Back at about 9:50. I'm always afraid of dislodging the audio recording while we're doing that, so it does keep recorded. I think we try to Absolutely.
Sit right.
I just want to make sure. I think I said 9:50, but if we're all back, I just want to make sure Miss Gilbert's still with us. Miss Gilbert, are you still there?
Yes, yes, I am.
I think if we're all ready, we can get back on.
Okay. I did go through and see when these inspections were dated, and 2021 and 2018 and 2019 respectively. And the real estate agent, the broker, sales or whatever, his thing was like 2023, and it was right before y'all sent this in. So I'm sure seeing it now. So why were these inspections, copies of these inspections, not included in the original before the administrative law judge, which would have substantiated much of what you're saying? Second question is, I know y'all are paying more in taxes than you probably think you should have to pay, but have y'all made any, I think you said in somewhere in the record that it was difficult to find anyone to give you any quotes on any of this. But over 7 years, I would think that you would be able to get some quotes and see how much it might cost to do this. The Assessment Appeals Commission has been quoted, I forget which one it was, but if you can say, all right, we've got to do X, Y, and Z in the electrical portion, and it's going to cost this much, that amount, that specific amount can be deducted from the appraised value that the assessor has. None of that's in here. So I wonder, those are comments, but I do have a question. Have y'all tried to get any of this fixed at all during this time?
Yes, we have patches on the roof and can't seem to figure out where the structures are attached. So it's constant movement on two different foundations. So it's hard to locate all. We have brought in, excuse me, we have brought in gravel to help mitigate some of the runoff, and hard to explain. The home is located out here on the mountaintop. We are pretty much the collection point for all the runoff from up top. Comes through our backyard, pretty much. Seasonal Creek. It also comes down the street, goes around through and percolates through the pad, so that the thing's constantly moving. The reason we didn't put any of that in to begin with, we figured that the fraud inherent in the system that created this would be enough.
Okay.
I literally had no other idea than educated, responsible people would see the same thing we've seen, I mean, right from the get-go. It's hereby declared to be unlawful for any person or partnership, corporation or association or any other entity or business to obtain, aid and obtain, or attempt in any way to obtain a license, permit, privilege, or any kind from the city or its employees or officers by the use of, or attempted use of any false representation, false statements, or any type of misrepresentation whatsoever. B, a license, permit, or privilege obtained by use of any means listed in this section will be void and considers not having any license, permit, or privilege. If we're looking at it, you got to go back to square one. The thing was a fraudulent bill. We contacted everybody involved as this went along. This hasn't been a slow, jerky movement. This has been a steady movement, continuous. On our due diligence in bringing these issues not only to you folks but several other people. I just can't figure out how the fraud. I mean, it would be no difference if I went out and robbed her. It's a crime. It's unlawful. And if it starts unlawful, it cannot magically become lawful after that point. It's common sense.
Any other questions? With that, we'll hand it over to the assessor to see if she has any comments or arguments she wants to make. It's not required to. And then if she does, we'll give it back to you for final comments. So Ms. Gilbert with the assessor's office. If you could, same question I will start off with is if you could state what you were asking the commission to do today, whether that be to remand and reverse the decision or otherwise affirm the decision, and then proceed with any arguments you have as to why the commission should or should not do that.
I agree with
And the decision. I'm sorry, go ahead.
Or go ahead, Ms. Gilbert.
I agree with the decision that the previous judge made, not knowing, what it was going to cost to fix the mobile home, to correct the problems. And so I agree with the decisions that she made.
Any questions of Ms. Gilbert? Questions? Seeing none from our commission members, seeing all shaking their heads no. With that, I'll hand it back over. I believe you might have had a question or something as well of me for the procedural elements. If not, just final comments from Ms. Van Riper's scene.
Had sent the assessor a registered letter.
Can you speak into the mic? I can't hear you.
I apologize. Can you hear me now?
Yes, sir.
I had sent the assessor office, actually 2 letters, one to her, Ms. Gilbert's predecessor. I'm pretty sure that one didn't get delivered. She was ill at the time and has since passed away. And Ms. Gilbert took over. I sent her a letter also the entire fraud situation, and you folks have a copy of that letter in your file. I don't know if anybody read it or not, but spent a lot of time researching this, and all the laws agree with me. It starts out fraudulent. It's never going to be truth, ever. It's going to be fraudulent all the way through. And like I said, I don't see the state or the assessor's office being a knowledgeable criminal party to this. I think this is all a new issue for you folks, and I encourage you to look deeply into it before you make a decision. I think the law stands behind me 100%. I mean, if I buy a car from you and you give me the wrong title, that's fraud. I get arrested for driving it. Until I tell them you sold it to me, they're supposed to go arrest you.
All right, if there's no more argument, no questions from the commission, at this time we'll enter deliberations. So once we enter deliberations, there's no more argument or communication from you to the commission members or from the commission members to you. The commission can ask Mr. Childress across from me questions, any legal questions. He can look up case decisions, and I'll otherwise guide you regarding the legal sufficiency of your conclusions. Other than that, I will hand it over to our presiding member, Mr. Phil Russ, to preside over deliberations.
I'm going to be a little unusual and speak first in this. My opinion, and if anyone agrees with me, they can make the motion. I would reverse administrative law judge's decision and go back to the county board. I think the administrative law judge acted arbitrarily. In my mind, everything is based on comments that taxpayer has made. In my mind, that's if I went down to the assessor in Davidson County and said, you have appraised my house too high, and I just think because it should be worth X instead of Y, that is certainly not reason to do that. And I think, and if it is indeed as you have described in terrible shape, why go from average to fair? Why not to poor? It's just arbitrary, pulled out of the air. There has been ample information provided in the exhibits that you had as to what all was wrong with this house or mobile home, but everything is based on the fraud. This body here, the Assessment Appeals Commission, we can rule or have expertise, quote expertise, on matters of value. The only time we ever get into something that might not be taxed is for tax exempt properties. And this property is not a religious property or an educational property or scientific property. I am not an attorney, but I would say that your redress in this matter goes to the people who you claim are fraudulent. I also think, and this is my opinion completely, you have made some very strong allegations, both in listening to the recording of the first hearing regarding the judge who heard that, and basically saying that this commission, that the State Board of Equalization, that the assessor's office in Cumberland County are complicit in a fraudulent and criminal act. So that kind of bothers me. I don't think any of us here, by choice, by sin of omission or commission, would do that. What you're asking and the basis for what you're asking for is not something that we are capable of doing. We are not a legislative or judicial body. So in my opinion, I would reverse the administrative law judge and accept the Cumberland County Board of Equalization's tax thing. But I as presiding officer, I don't think I can make a motion. But I did want to go first and just say that. So
I'm in agreement with you, and I do have a hard time with fraud being tossed around like it is, because it is a taxable structure, and it should be taxed. Now, getting to what the value should be, I agree. Bring in people, get numbers, and see where that's at. Get the licensed people. I don't know that the licensed people had been gotten. So I'm going to agree with what you've said. I think a lot of this case needs to be somewhere else. So I'm in agreement.
Would you like to make a motion as to what we want to do with, or you want to listen to the
Oh, I'd like to hear the others, and then we can.
Mr. Turner?
I concur with Ms. Clanton and Mr. Russ. I concur with what you're saying.
Yeah.
Mr. Bowles?
Yeah, I do too. I think it's an unfortunate situation that we're just the wrong body to hear this kind of make a decision on this kind of situation. Actually, so I agree with what.
Well, I'll go ahead.
You can make the motion as well.
All right. I would move that the administrative law judge's decision is reversed and that the decision of the Cumberland County Board of Equalization be affirmed.
I'll second that.
Yes.
Okay, there being we can do a voice vote since you're all here in person. All those in favor say aye.
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 All those opposed? There being no nays, the motion carries unanimously. So procedurally, what will happen from here is the decision's been reversed. The decision will be reversed and remanded to the administrative judge. So
No, I didn't say remanded. I said
procedurally, it has to be remanded.
Oh, okay. Okay. I'm sorry.
I'm telling you, that's what's happening. So the decision will be reversed and remanded to the administrative judge, essentially make those changes. What will happen for your case is we will box this up. We will we'll send a written order in the next 90 days, codifying that decision and clarifying those next steps. We'll go back to the Administrative Procedures Division, who will otherwise issue that final order and otherwise close out this file. You're welcome to then appeal this decision to Chancery Court. Once you get that final order, it'll tell you your deadlines for doing so. If you don't, it'll otherwise then go back to the administrative judge and be closed out. But that takes care of our proceedings today. Go ahead.
And be closed out. So where does this sit right this minute? Be a little more blunt.
Yes.
Okay.
So the decision has been reversed by the commission
So
today.
the original decision that the judge made, it should be cut in half, has been canceled.
Correct.
And back to your A, taking appeal of that decision, or
The county board, county board of equalization value, that being that $254,600 market value for the entire property for an assessment value of $63,650.
But that doesn't affirm the original judge's decision.
Reverses the judge's decision.
Erases that decision.
Correct. Your options would then be either appeal of that final written decision from this body to Chancery Court, or otherwise you can let let it become final, and you can appeal your assessment next year. But that'll take care of your proceedings today. In the next 90 days, we'll send a written copy of the decision from today to you. Possibly sooner than that. We just have to do it within 90 days. And then from there, procedurally, what happens is it goes to the administrative judge for final adoption, and then we'll otherwise go out. With that, that concludes our first appeal today. We'll move over to our second appeal. I'll ask quickly, does anyone need a break before we do that? All right, seeing none, we'll move over. Our next appeal is going to be a matter of Sweetwater Preservation Trust versus the Monroe County Assessor of Property. Ms. Gilbert, I see online as well. You're welcome to stay and observe. These are public meetings, but you don't have to stay online if you do not want to.
I do not want to, thank you.
Thank you.
A copy of the recording.
Sure. If you could just send me an email request and we'll get that to you. It'll also be available online within 3 days. All right, our next order is for, in regards to Sakura Preservation Trust. Let's see here. I would typically read the order aloud, but I want to make sure we have both the parties here. Otherwise, may not be necessary. So we've got, see Mr. Lee in the room. Mr. Lee, if you could introduce yourself.
Thank you, Mr. Pope. Yes, it's Robert Lee. I'm the attorney of record for behalf of Monroe County Assessors.
I don't see anyone online or in the waiting room. If you are here on behalf of Sakura Preservation Trust or otherwise here on behalf of Dr. Freed, I guess please stand up or let us know. Seeing and hearing no one, I'm going to check my email briefly to see if I have any communications from the representative for the taxpayer today. Checking my email, I do not see any emails or communications from them or missed phone calls. So with that said, I guess Mr. Lee, you are not the appellant, you are the respondent or appellee in these proceedings, is that correct? Just defending it.
Therefore, Mr. Pope, the commission, we will move that the appeal to the commission be dismissed. The order dismissing the appeal for lack of jurisdiction be upheld.
So to the commission, essentially what that means, if the appellant is not here today to represent their appeal, This isn't necessarily a review here. And this isn't necessarily like an independent chore of yours. It is the appellant's responsibility to be here and present their appeal to you. You've heard the motion from Mr. Lee. I'm going to ask you a couple of questions just to make sure if you agree with that. So for a default proceeding, essentially, I'm going to ask you if you find that the notice of today's hearing to be sufficient as included in the materials. If you would like, I can reprint out a copy and get a copy of that notice of hearing for today. I will note that in the administrative record, or the, the notice of administrative record that I sent out on behalf of our State Board of Equalization on July 14th, 2023. I will note that on page 165, we included the notice of hearing for today. That notice of hearing is approximately 3-4 pages. Includes a notice that today the hearing was to be today, Thursday, September 21st. And the location would be in the Cordell Hull Building, 2nd floor, Volunteer Conference Center, or virtual attendance using the attached instructions. And it was mailed to Dr. Sue-Ann Freed at 1000 Highway 180, Hiwassee, Georgia, area code 30546-5408, and her email address, suan@enota.com. So now I'll ask the commission if you find that notice to be legally sufficient and the taxpayer not here, and you would otherwise like to grant the motion to default. I was thinking you have to do this in a motion or just say aye, I guess. If you have I would ask if you have a motion to affirm that the dismissal, make a motion, and then we can there. It's up to you guys.
I would move. Well, I'm not supposed to. I'm sorry, I did it the last time.
It's okay. You can. We're informal.
Motion to dismiss.
Yeah.
Second.
All those in favor? All those opposed? Being no nays, it carries unanimously. That concludes our business for today. Thank you all.
I do have a question from Mr. Lee. The 2 years that are in that weren't thrown out before because of the delinquent taxes, have those appeals ever been heard for the valuation of the property?
The 2 years, are you talking
So
about?
2017 and 2020.
18 and 19.
The 2017, the reappraisal was 2018. That never was appealed. 2019 never was appealed. 2020 was appealed on valuation, but there's delinquent taxes for 17, 18, 19, 20. Now there's delinquent taxes for 21, 22. So this matter is also pending before Chancery Court, 2 Chancery Courts in Knox County, which we have motion hearings on Monday.
Okay. I didn't want to short circuit anything if they were supposed to I just didn't understand then, I guess, the whole thing, which is not unusual. That was a lot of stuff on that one.
Very unusual case.
Okay. With that said, that will conclude our proceedings today. Thank you all. I'm going to hit stop on the recording.